Welcome back. This time, about part two, it starts with tax distinguished from a license fee and other concepts. Why is it important for you to know the distinctions between a tax and license fee? This is so because there are certain limitations that apply to a tax and do not apply to a license fee and vice versa. So let's have a look at the instances when bar questions were given on the subject. When you look at this, you would notice that it was very popular sometime in the 60s and 70s, after which it disappeared entirely. So for purposes of forecasting the bar examinations, we have to look at the clustering, meaning to say what we should concentrate on to be those within the 2000s, starting from 2000 up to 2010, 2019, etc. These are all the probables for the bar. But these ones that were popular in the past, we still have a possibility of being given in future bar examinations. That's why we're still discussing them as well. So, when you're made to distinguish, do not define them and lay them side by side. For example, if you're made to distinguish between a tax and license fee, you don't define a tax and then lay it side by side the definition of a license fee. That's not the way to distinguish. But that's the way to define, but not distinguish. So if you're going to be able to distinguish, look for the areas where they differ, in short, the basis for the distinctions, and then that's what you're going to discuss. So let's look at the first area of distinction, the purpose. A tax is basically for the purpose of raising revenues, while a license fee is for purposes of regulation, in short, to promote the general welfare and to protect the health, safety, and morals of the inhabitants. Therein lies the first difference. As a result of the first difference, you have the second difference with respect this time to amount. Since a tax is for revenue purposes, then the amount collected is practically unlimited. Sometimes it is even said that the power to tax includes the power to destroy. However, with respect to a license fee, the amount collected should only be limited to the cost of inspection, supervision, regulation, and control. It should not go beyond that. Otherwise, there will be an illegitimate exercise of police power. This time, let's look at the time of payment as a point of differentiation. A tax is usually paid after the business has already started. As a matter of fact, when you talk about income tax, it is the result of business operations upon which the tax is going to be paid. Upon the other hand, when you talk about a license fee, it is a precondition for the start of a business. That's why it has to be paid first before you start a business. What about the mode of payment? Insofar as the mode of payment is concerned, when you talk about a tax and a license fee, there seems to be no major differences. Why? Because when you talk about the mode of payment for tax, it is usually in money. And by the same token, when you talk about the mode of payment for license fee, this is also in money. The point of difference again is the effect of failure to pay. As we said, the payment of a license fee is a precondition for the operation of a business. You could not start a business without paying license fee first. And therefore, if you fail to pay the license fee, then your business is illegal. Upon the other hand, since taxes are paid after the business has already operated, then failure to pay the tax does not make your business illegal. It merely makes you a tax evader. What about surrender of certain prerogatives? When the tax is paid, the government does not surrender any of its prerogatives. Upon the other hand, when a license fee is paid, there is a surrender of some of the governmental prerogatives. Why is it so? It is so because when a license fee is paid, the licensee is authorized to operate certain activities which he could not engage in unless you would have first paid the license fee. Taxes may be subject to exemptions, but license fee are not subject to exemptions. What about relation of the non-impairment clause? Taxes arising from the power of taxation are subordinate to the non-impairment clause. So therefore, you could not impose a tax if you don't impair the obligations of contracts. Upon the other hand, license fee being a collection under the police power is superior to the non-impairment clause, such that you could even impose a license fee, even if it would impair the obligations of contracts. Why is it so? Because the exercise of this power is more urgent than that of taxation. We have finished with the discussion of the differences between a tax and a license fee. So, how are questions evolved or crafted arising from the concept we have just discussed? As a general rule, there are two types of bar problems. One would be the objective type, the other would be the fact-based problem. Under the objective type, there are two subtests there. One would be the enumeration type, purely objective, enumeration type, definition, and distinctions. And you have the other type here, the other subtype, which is a theoretical discussion of a particular concept of the law. And then you have your fact-centered problem, where in fact there's a story. For example, A was walking along the beach. He met C. He didn't like the face of C, so he decided to shoot C, and C died. So you have a story. But for this particular area, I doubt it if you're going to have a fact-centered problem. As a matter of fact, the questions I see here will be the purely objective type, plus a theoretical discussion such as this one. So having seen this, how are you going now to explain and answer this? You remember we talked about the enumeration type before? We have to use either the vertical or horizontal type of analysis. So use that. And then you have the theoretical discussion. Why are these distinctions important? We said a while ago that the distinctions are important because of the fact that there are limitations that apply to a tax but do not apply to a license fee. So that's why we said, let's have a look at this one. Now, having said that, let's have a look at another point of distinction. This time, it is between a tax and a special assessment. But what is a special assessment? A special assessment here is any enforcement made of recovery by the local government of the expenditures that were made for the construction of infrastructure that would have benefited a particular parcel of land within the territorial boundaries of the local government unit. So let's make a distinction then. Well, as usual, we look at the historical antecedent. So again, when you look at this, there was just a question in 1965, and this is really one of those that are nice to know. So even if you're not able to remember this, don't worry. In all probability, it will not be asked in the bar exams that you're going to take. So as usual, we'll have to look at the basis for distinguishing between the different concepts, such as, for example, here, between a tax and a special assessment. The first point of distinction is the subject. The subject of a tax is almost always general, meaning to say you could impose a tax on practically all subjects and objects that will be found on earth. On the other hand, when you talk about the special assessment, the subject there is only land or real property. With respect to amount, as we said before, since the power of taxation here is revenue raising, then again the amount here is practically unlimited, and sometimes, it's even said, includes the power to destroy. However, with regard to special assessment, the amount is limited only to the recovery of the expenditure made by the local government. Who are liable for taxes? Well, anybody could be liable for taxes, but the special assessment is imposed only upon the land benefited by the public works expenditure, nothing else. The special assessment cannot be collected on other lands that has been benefited. What is the basis again? The basis of taxation is the power of taxation. So you're able to collect the tax based on the power of taxation. And consequently, there must be a national legislation in order to be able to collect the tax. But when you talk about the basis of special assessment, usually it is the local governments that collect this purely to be reimbursed insofar as expenditures are concerned for infrastructure benefiting certain parcels of land. So with regard to application, then there's also something that's different here. And what is the point of difference? The revenue collected from taxation are generally used to meet the legitimate objects of government. In short, to meet governmental functions. Upon the other hand, the amounts collected from the special assessment is merely going to be used here to benefit, or in short, to have a reimbursement of the expenses made by the local government unit. With respect to surrender, when you collect the tax, there's nothing surrendered by the government. But when you collect the special assessment, then again, what is surrendered there is the ability to make use of the property in some other way other than the benefit that's been derived out of the public infrastructure. Let's go back. What questions may be taken out of this? I doubt it if there will be a fact-based problem based on the differences between a tax and a special assessment. Generally, going to be an objective of this character. Distinguish taxes from assessment. So, we go to the next area, the distinction between a tax and a debt. So, why is it important for you to know the distinctions between a tax and a debt? Again, for bar purposes, notice it's not that important. Why? Because there were only two times in the past when a question was sourced from this particular area. And it was a long time ago that we had a last question, and that was in 1992. But just the same, let's have a look at it, and therefore let's continue and have a look at the distinctions between them. So again, there are more bases for distinctions here between a tax and a debt. In lectures, this is normally emphasized upon, but to my mind, just have a look at it, and we'll have to note what are the specific areas here that may be possible. Remember the word possible, not probable, for the bar exams. First, what is the basis? The basis for a tax is always statute. If there's no statute that imposes the collection of a tax, then the government could not collect a tax. So technically, it's an enforced contribution. You are forced to pay the taxes. Upon the other hand, the basis for the debt is the agreement between parties. So when you talk about agreement within the parties, it's usually contractual in character and voluntary. So you could choose not to enter into an agreement and therefore you don't have any debt. Now, what about the effects of failure to pay? The effects of failure to pay are found in the Constitution, specifically in the statement that no person shall be imprisoned for non-payment of a debt or of a poll tax. So you notice if you don't pay your debt, you couldn't be sent to jail. You could be sued, but you couldn't be sent to jail. It's not a criminal act if you don't pay your debts. On the other hand, non-payment of taxes is criminalized, such that if you don't pay your taxes, you could be sent to jail, except if the tax you didn't pay is a poll tax. So let's repeat again. No person shall be imprisoned for non-payment of debt or of a poll tax. So, but what is a poll tax? When you talk about a poll tax is nothing more than a tax imposed on a per head basis, on a per capita basis. And the example we have of a poll tax is the current community taxes that are being paid before you could be issued the community tax certificate. What about the mode of payment? Taxes, the obligations created by taxes are generally extinguished upon payment of money. But when you talk about the extinguishment of the obligations created by debt, then notice there are so many ways of extinguishing that obligation. Payment or performance, loss of the thing due, you have remission, condonation, etc., etc. So there are so many ways if it is a debt. A tax is not assignable, being a duty owed by the inhabitant to the state. It's not assignable. You could not transfer that. Upon the other hand, when you talk about a debt is usually assignable. Taxes could generally not be the subject of compensation and set-off. Upon the other hand, one of the modes of extinguishing an obligation created by debt is compensation and set-off. That's why debts could be the subject of compensation and set-off. Delays in payment also is a point of difference. Why? If it's delay in payment of taxes, then it is almost always that interest is due. But if it's delay in payment of a debt, whether interest is paid or not is dependent upon the agreement of the parties. If the parties didn't agree that interest should be paid, then no interest should be paid. The periods of prescription also differ. The periods for prescription of taxes are shown and enumerated in the different tax laws. For example, the National Internal Revenue Code, the Customs Modernization Tariff Act, you have the various miscellaneous taxes. But when you talk about the periods of prescription of a debt, it is always governed by the provisions of the Civil Code. Now, what about the authority that imposes it? It's similar to basis. Since taxes arise from law, then the authority that imposes it is nothing more than the government. But when you talk about the debt, it's nothing more than the agreement between parties. That's why the authority here is the private party involved. So let's look at typical bar questions here. Of course, notice you have again the distinction type, and you know how to approach this already. Vertical and horizontal type of analysis. We said there are differences between a tax and a debt. And in that particular regard, I would also would like to remember that there are certain instances when a tax is also considered a debt. We have the 1957 case of Zambrano versus Court of Appeals. The Supreme Court in this particular case held that a tax is considered a debt because the tax is also enforceable by judicial action. In 1963, we have another case, this time this case of Republic versus Far East American, and it's held there that there are instances when a tax is considered a debt, especially with regard to period of prescription, because for bonds, because the payment is similar to debts. And then we have this last case of Commission versus Palanca. Why? Uh, Here, a tax is considered as a debt sometimes for purposes of deducting interest paid for delinquencies in the payment of business taxes. So those are the instances when a tax is also a debt. We have another area in the coverage, but this time notice that we'll have to look at them one by one because some have been sources bar exams in the past, the others are not. So let's see. All right. The first one here is the distinction between the power of taxation and police power. Is this probable for the bar exams you're going to take? I doubt it. Why do I doubt it? I doubt it because you notice there is no pattern here when the question was given. Why? In the 60s, only one question was given. In the 70s, also only one. 80s, none. 90s, none. It's only the 2000s that you have a question in 2003, after which there were no more questions asked. So this is also one of the areas that I refer to as merely nice to know for the review. So if you don't have much time, just have a look at it. So as usual, we look at the areas where they differ. And when you look at the areas where they differ, the areas where they differ sometimes is similar to the distinctions between a tax and a license fee. Why? A tax is collected under the power of taxation, while a license fee is collected under police power. So therefore, the points of differences are sometimes similar. So without much ado, let's now go forward and discuss. The first point of distinction is with respect to purpose. The power of taxation has for its purpose basically revenue raising, while police power has its basic purpose, the promotion of the general welfare and to protect the health, safety, or morals of inhabitants. So it's basically, again, for regulation. With respect to amount, the power of taxation, again, here, enables the state to collect almost unlimited amounts of money, such that this even said that the power to tax includes the power to destroy. However, when you talk about police power, the amount collected under police power is only limited to the amount, again, that is used for supervision, inspection, and control, nothing else. And therefore, if the amount exceeds it, there would be an illegal exercise of police power. What about property taken? As a general rule, the property taken under the power of taxation is always money. It's money that's taken, pera. But under the police power, what is taken generally is the property that causes the evil. In short, the property that causes danger to the health, safety, or morals of the populace. But is it an adage that money is the source of all evil? No, is then that money is not taken under police power? Notice, money is not the source of all evil. It is the inordinate love of money that is the source of all evil. That's why it's not taken under police power. What happens to the property taken? In this regard, the power of taxation is constructive in character. Why constructive? Because the money that's taken from the taxpayer is utilized to fund public services, to build infrastructure like hospitals, provide medical services, to provide police services, provide educational services, etc., etc. Upon the other hand, when you talk about the power known as police power, this generally destructive in character. Why? Because the property taken is usually destroyed. And what do you mean usually destroyed? Oh, you have the pornographic material that's taken. You have the shabu that's taken. You have the ruinous building that's about to fall. All of these are destroyed under police power. That's why police power is basically destructive in character. Having said that, what compensation then or benefit does a person derive from the power of taxation compared with police power? You would have seen, as I discussed, that the power of taxation is constructive and it benefits directly, the expenditure can be benefits directly the general populace. Upon the other hand, the person whose pornographic materials, whose shabu was taken, whose building was destroyed, what benefit did they get? Well, the benefit they get is the feeling that they were able to do something good for their community. What about the relation of the non-impairment clause to the power of taxation and police power? Taxation is subordinate or inferior to non-impairment clause. In short, the power of taxation could not be exercised if it would violate the non-impairment clause. On the other hand, police power is superior to the non-impairment clause, such that police power could be exercised even if it would violate the contractual agreement between parties. But why is this so? This is so because the need for police power is more urgent than the need for taxation. So remember again, you don't pay your taxes, the state will perish. But the state will not perish immediately. It will take a long time before the state would vanish. On the other hand, if you not destroy the mad dog that's running around, you don't kill, you don't kill also the source of the evil, such as, for example, here, you don't uh, you don't confiscate the pornographic material and destroy it. You don't confiscate the shabu. You don't destroy the ruinous building. Then in a little while, somebody's going to get hurt. Now, what about the scope? Insofar as power taxation is concerned, generally, only property rights are affected. But when you talk about the power taxation, then not only property rights are affected, even personal liberty may, in certain instances will also be affected. For example, under the police power of the state, we have again the lockdowns and people are prohibited from going out to the streets. What about surrender? Is there something surrendered when you pay the tax? None. Similarly, under the differences between a tax and a license fee, when you pay your taxes, you don't surrender, the government does not surrender any of its prerogatives. But when you pay a license fee under police power, then the state gives up certain of its prerogatives, and consequently here, the licensee is allowed to do something which is not allowed to do unless you first pay the license fee. So, having talked about the distinctions between a tax and a license fee, and also having made a distinction between the power of taxation and police power, the Supreme Court came up with a criteria for distinguishing between a tax and any imposition under police power. And what is that? Supreme Court said that if the generating of revenue is the primary purpose and regulation is merely incidental, the imposition is a tax. On the other hand, if the regulation is the primary purpose, the fact that incidentally revenue is also obtained does not make the imposition a tax. So you always look at the basic purpose in order to know whether the imposition is under police power or under the power of taxation. The Supreme Court then reiterated that the purpose and effect of the imposition determine whether it is a tax or a fee, and the lack of any such standards for such imposition gives the impression that the same is a tax. So, what bar questions could possibly be derived out of the concept we have discussed before? Now, here, this time, there could be fact-centered problems arising from this or theoretical discussion problems. So let's have a look at the first typical type of bar questions. It's a simple distinction, but notice the question is not asking you to state all the differences. There are only two areas of distinction that the question is asking. Therefore, in your answer here, what I would suggest that you do is that you follow the same technique we talked about before, insofar as the vertical and horizontal technique of answering questions are concerned. Now, you have a fact-based problem. When you have a fact-based problem and it is long, I normally suggest that you go to the question at the bottom of the problem in order to know what the examiner wants. Why? If the problem is long and starts from the very beginning, by the time you reach the bottom, you would have forgotten everything already. But if you know what the examiner wants, as shown at the bottom of the problem, Then as you're looking at the problem, you start recalling concepts you learned in the past and try to apply them. And you're therefore already solving the question asked at the bottom of the problem. So let's go back and have a look at the question from the very beginning, analyzing again the set of facts as we encounter them in the light of the questions asked at the bottom of the problem. So the question is the ordinance valid? So when you look at this question, is the ordinance valid? Automatically, your mind should race to determine what are the requisites in order to make a valid ordinance. That's what you're going to look for. As we read the problem, we'll have to do some analysis. In other problems, succeeding problems, we not do that anymore. It should be automatic for you how you're going to address the questions if it is in fact a fact-centered problem. So we now try to address the question, is the ordinance valid? The city of Makati, in order to solve the traffic problem in its business districts, decided to impose a tax to be paid by the driver. Let's stop there for a while. So what power has been exercised here when there was an imposition of the tax? Is it police power or is it the power of taxation? We learned the lesson that it should be the purpose, the undergoing spirit of the reason why there was an enactment that should look at in order to know whether it's an exercise of police power or the power of taxation. Here, to solve the traffic problem is under police power. So this is an imposition under police power even if it was denominated as a tax. So let's continue. Decided to impose a tax to be paid by the driver on all private cars entering the city during the peak hours from 8 a.m. to 9 a.m., from Mondays to Fridays, but exempts those cars carrying more than two occupants, excluding the driver. Is the ordinance valid? Explain. So you will notice you have to explain again why the ordinance is valid as an exercise of police power. But also, when you look at this, notice there are exemptions. So when there are exceptions, there is in fact a differentiation. There is a discrimination. Why is it so that there is a discrimination? Because those cars carrying more than two occupants are exempted from the payment of this particular tax. But those cars that carry less than two occupants, excluding the driver, are subject to the tax. So the problem here is that, is there a valid classification? So this is a review, so you more or less would know what the elements of a valid classification are. But to refresh your memories, in order to have a, by the way, every time there is a tax law, there is always a classification. One group is subject to tax, the other group is not subject to tax. So there is always a classification. But the issue is the classification valid? In short, subjecting some to tax and not subjecting the others to tax. So what are the elements here of a valid classification? First, there must be substantial distinctions between the subjects. In short, they should really be different. Those which have more than two occupants, are they substantially different from those that have less than two occupants? Yes, they have. Is this distinction germane or related to the issue? What is the issue here? The issue is to limit the number of vehicles entering the city of Makati. And therefore, the classification of exempting vehicles that have more than two passengers compared with those having less than two occupants is germane, is related to the purpose of the law, which is to limit the number of occupants. And therefore, I have the other element that I not discussed anymore. It's only these two elements that are important for you to remember with respect to elements of a valid classification. So, let's now look at two types of answers. The types of answers I suggest is dependent upon the subject weight, meaning to say, if the weight is 5% or less, then the examiner again is giving you a lesser number of minutes in order to be able to answer. So if your answer is very long, you might not be able to write it down within the time limitation, and consequently, you'll be robbing the time of the other questions as well. But If the subject weight is 5% or more, then the examiner is trying to test something else. He's trying to test not only your knowledge of the law, but also the facility of written expression. So let's come up with suggested answers here. Now, when I look at the suggested answers, I'll go very fast. But you could always go back to the materials and have a look at them carefully for careful analysis and emphasis. So look at this. You start with the conclusion and the answer is short. Now, when you analyze the answer, you will notice that everything has been taken up already. In short, if there is a question why, your answer is not yet complete. So let's analyze. Yes, but why yes? Why is it that the ordinance is valid? Because there is a valid exercise of police power and there is a valid classification. So you don't stop there. You must explain why there is a valid exercise of police power and why there is a valid classification. You must explain that now. So let's explain. Limiting the number of private cars, which reduces pollution, as well as the incidence of traffic accident, is a valid exercise of police power. Why? Because it protects the health and safety of the inhabitants. There is a valid classification because there exists substantial distinctions between those exempted and those that are not. But why are there substantial distinctions? The classification is germane to the purpose of the law, which is to limit the number of private cars within the business districts of the city of Makati. On the other hand, if the weight is more than 5%, then you must expand. So let's look at the expansion here carefully. So the same. Providing the exemption would encourage more passengers in a single private car, resulting to fewer vehicles on the road. Now we look at another area here, which is the joint exercise of the power of taxation and police power. Why is it important for you to know whether there is a joint exercise of the power of taxation and police power? Remember a while ago we said that the strength of one power here covers up or makes up for the limitations or deficiencies of the other power. For example, here, the strength of taxation is that the amount collected is practically unlimited. On the other hand, under police power, the amount collected is limited only to the cost of supervision, inspection, and control. That is why in that particular regard, if there is a joint exercise, then the weakness of police power is overcome by the strength of the power of taxation. So let's look at historical antecedents here. Again, notice in lectures this is given much emphasis, but I think it's enough that you've heard it. Why? Because it's merely a stay area. There is no set pattern to expect what it will be given in the bar examination you will take. Much is the same, anything is possible under the sun, so just have a look at it. So, let us have a look at instances when the Supreme Court ruled that there is a joint exercise of the power of taxation and police power. We start with the case of PAL versus Edu, where the Supreme Court held that the LTO fees are a joint exercise of the police power and the power of taxation. Then we have the case of TIO versus Videogram Regulatory Board. In this case, TIO questioned the amount of fees that are being collected by the BRB for the establishment of videogram establishments. He claims that the amount being collected is higher than the cost of regulation and inspection, etc., etc. But the Supreme Court said, hey, wait a minute. This is a joint exercise, and therefore the weakness of police power is overcome by the power of taxation. Then we have the COCO levy funds. We also have the oil price stabilization cases under the case of Baserda versus Maraig, which also considered a joint exercise of the power of taxation and police power. We finish our discussion of the joint exercise of the two powers. Let's now talk about the instances where there was an exercise of police power and not the power to tax. The first is when there is a regulation of non-useful occupations, then that is a pure exercise of police power and not the power to tax. So, what is the leading case here? The leading case, of course, is the case of Koonyeng versus Pastone. Now, in this particular regard, I would like to remember that in the case of Koonyeng, the Supreme Court said that if there is a license fee collected for the regulation of non-useful occupation, then the amount of license fee could exceed the cost of supervision, inspection, and control. Why? Because the very high license fee would make the operation of the non-useful occupation more expensive, and therefore that would drive out of existence the non-useful occupation. But it's not the only instance when there is an exercise of police power, but the cost could exceed the cost of inspection, supervision, and control. Yes, as we talked about a while ago, if there's a joint exercise of police power and the power taxation, then the amount collected could exceed the cost of supervision, inspection, and control because the weakness of police power is overcome by the strength of taxation. What is the second instance? The second instance is the famous case of Lutz versus Araneta, reiterated in the case of Bacolod Murcia and subsequent cases. What was the story there? The Supreme Court held that the imposition upon the sugar industry to build a fund in order to rehabilitate the sugar industry is an exercise of police power to promote the general welfare and not under the power of taxation. Why so? Because the Supreme Court said that to rehabilitate the sugar industry is in fact for motive of general welfare, because the sugar industry is one of the pillars of the Philippine economy, contributing employment opportunities and also contributing scarce foreign resources or scarce foreign exchange. And then we have the case of Caltex, where the Supreme Court held that the imposition of margin fees on branch profit remittances to curb excessive demands upon foreign international reserves is an exercise of police power and not the power of taxation. So let's have a look at typical bar questions that could be evolved out of the area that we just discussed. We have this. This is a theoretical discussion problem. What about license fees by virtue of what authority may they be collected? Is there any exception to the rule that the amount of license fees may not exceed the amount needed to defray cost of inspection and regulation? As usual, license fees are collected by virtue of the police power, etc., etc. Is there any exception? Yes, in fact, there are two exceptions, and proceed to enumerate the exceptions. As usual, the length of our answer is dependent upon the subject weight, and let's have a look at the suggested answers here. So, let's have a look at that. Look at it later on at leisure. This is for 5 percentage points or less. Then you have more than 5%, expanded answer, longer answer. Then you have another question here, which is basically an objective type of question, asking for a definition and illustration. So, notice, I didn't come up anymore with more than 5, less than 5, because the opinion questions are usually below 5%. And then you have one that's similar. So this time is a theoretical discussion problem. That's why you could have less than 5 or more than 5. The police power, the power to tax, and the power eminent domain are inherent powers of government. May a tax be validly imposed in the exercise of the police power and not of the power to tax? If you answer the affirmative, give so. Of course, yes. Then you proceed to discuss the case of Konying. You proceed to discuss the case of Caltex. You proceed to discuss the case of case of Lutz versus Araneta. So any of the three would suffice already as your answer. But as I said, you have here 5 or less, and then more than 5. Let's look at the issue of eminent domain. Eminent domain is a subject that's discussed in the review for political law as well as remedial law. The only reason we're going to discuss it in taxation is because of the fact that in 2013, there was a reversal of a prior doctrine of the Supreme Court, the case of Central Luzon drug, that stated that the 20% discount given to senior citizens is considered here as an exercise of eminent domain. Why? Because when establishments were required to give the 20% discount, there was taking of the property of the establishment, and therefore there must be just compensation in the form allowing them to use it as tax credit. So that's the reason why I would like to have a look at this particular area. This was the subject of our exams only once in 2016, and therefore since within the parameters, again, as I said, the year 2000s, then I consider this as one that may be probable in character. So let's look at the limitation insofar as eminent domain is concerned. Private property shall not be taken for public use without just compensation. So, if the taking is under police power, there is no requirement for just compensation. But if the taking is under eminent domain, then it is imperative that there must be just compensation. But how did the Supreme Court balance this area between the power of taxation and eminent domain? The Supreme Court came up with a distinction, although Supreme Court didn't state it directly, that insofar as eminent domain is concerned, what's taken here is physical property, tangible physical property, not intangible, like the senior citizen discount. So, yeah. You have the case of Central Luzon drug, decided as far way back as 2005. Remember, the doctrine has already been reversed. But what is important for you to remember is the basis for the reversal. In short, what was the reason why there was a reversal? And in not so many words, I said, you must now discuss the concept that eminent domain pertains only to tangible property. It does not refer to intangibles. So, the tax credit given to establishments is just compensation for the 20% discount, which is private property deemed taken for public use. Let's go back and have a look at the story here. The story is that there was a law that was passed requiring all establishments to give a 20% discount to senior citizens. And at the time, the 20% senior citizen discount was allowed as a tax credit from the income taxes due from the establishments that gave the 20%. Question: what is meant by tax credit, and how is it distinguished from tax deduction, and which is better between the two insofar as the taxpayer is concerned? A tax credit is the deduction for the tax that is due. So you have, for example, here, visualize the computation. Gross income less deductions equals income subject to tax multiplied by the tax rate, and then you have the income tax that's due. From the income tax that's due, that's where you deduct the tax credit. Upon the other hand, when you talk about deductions, it's a reduction of the gross income in order to reduce the income subject to tax. So you have gross income less allowable deduction equals income subject to tax multiplied by the tax rate, then you have the tax that's due. So you notice, it is more advantageous to have a tax credit compared with the tax deduction. So having said that, so the reason why this was considered again as subject to just because it was considered as eminent domain. But as we said, the 2013 case of Manila Memorial Park, which was cited in the case of the 2017 case of Southern Luzon drug, reversed the 2005 doctrine in the case of Central Luzon drug. So, here. The Supreme Court said that the 20% senior citizen discount and PW discount is not considered as taking property under eminent domain. Why? The Supreme Court came up, although remember my warning, Supreme Court did not specifically say that in eminent domain, property taken is tangible personal property. Supreme Court didn't say that. Instead, the Supreme Court came up with characteristics of taking in order to make it under eminent domain, subject therefore to just compensation. So, what then are the characteristics of taking as a concept under eminent domain? First, the expropriator must enter a private property. So you would say probably think it's land, but the tangible personal property could also be entered upon. So second, the entrance into private property must be more than a momentary moment. Third, the entry into property should be under warrant or color of legal authority. Fourth, the property must be devoted to public use or otherwise informally appropriated or injuriously affected. Fifth, the utilization of the property public use must be in such a way as to oust the owner and deprive him of all beneficial enjoyment of the property. But remember, Sada, although this was initiated in 2017, this is merely a reiteration of a doctrine that was said way back in 2013 that reversed the 2005 doctrine in the case of Central Luzon drug. So, the Supreme Court therefore concluded that imposing discounts and then allowing them as deductions is legal. Why? There was an amendment of the law that now allowed the 20% discount to be used as deductions and not anymore as tax credits. Supreme Court said this is legal. So why is it that this is legal? I remember it asked once in 2016. Therefore, it's a problem. So the Supreme Court does not doubt the legality of the method taken by Congress to implement the legal policies of the subject law. That is, to impose discounts on the medical services and purchases of senior citizens and PWDs, and to treat said discounts as tax deduction rather than tax credit. So remember, the law was changed from tax deduction to tax credit. And the Supreme Court said this is legal. Why? The measure is fair and reasonable, and no credible proof was presented to prove the claim that it was confiscatory. To be considered confiscatory, there must be taking of property without compensation, just compensation. But remember, it becomes illegal only if the taking without just compensation is under eminent domain. But we said it's not under eminent domain. Let us look at the bar question that was derived of the discussion we made a little while. This is a fact-based question, therefore we go to the bottom of the problem to find out what the examiner wants. But when you look at the question at the bottom, you're going to be surprised because you don't even have to read the facts in order to be able to answer the question. As a matter of fact, this is what falls under the concept of a theoretical discussion problem. As usual, you have answers whether it's a 5% question or more than 5%. The question here, which is short. But you must expand it if the weight is more than 5%. So, Let's have a look at the question again because there is sub-question here. And when you have the sub-question, you go to the question at the bottom. So you would notice now that the sub-question is in fact here a fact-centered question. So you must look at the factual antecedents. So when you see question B, you now have to go back and look at the problem in order to solve it. If you were the judge, how will you decide the issue? Briefly explain your answer. So find out exactly what is the issue. What are they quarreling about? So go back and have a look at the problem now from the beginning. Congress issued a law allowing a 20% discount in the purchases of senior citizens from among others recreation centers. This 20% discount can then be used by the sellers as a tax credit. At the instance of BR, however, Republic Act 9257 was enacted, amending the treatment of the 20% discount as a tax deduction. Equity Cinema filed a petition with the RTC claiming that RA 92 is unconstitutional as it forcibly deprived sellers a part of the price without just compensation. So remember the issue here is trying to determine and understand, is the taking under eminent domain or is it taking under police power? Why? Because if the taking is under police power, then there's no need for just compensation, and therefore, as judge, you will have to sustain the constitutionality of Republic Act 9257. Now, here, since this is a sub-question, generally the weight is 5% or less if it is a sub-question. So we don't have any more 5% or less or more than 5%. So I will decide in favor of the constitutionality of the law. In the 2013 case of Manila Memorial Park versus Department of Social Development, the 20% held that the Supreme Court held that the 20% discount is a valid exercise of the state's police power. And that's it. That's the end of Module 1, Part 2. Let's now have a break and take our merienda. After the break, we shall take up Part 3, which includes distinctions between the power of taxation, power of domain, and other concepts. So enjoy your break.